NK Goswami sir. NK Goswami
Yes.
sir. Sir,
Yes,
you are
yes.
item number 15.
Yes, yes.
Fine, sir. You should write Narendra Kumar Goswami sir. Fine, thank you.
I'm just amending the same.
Fine. Item number 5, Durasamy sir. Durasamy sir. Item number 5, party in person. Sir, can you hear me? Durasamy sir, can you hear me? Sir, can you hear me? Durasamy sir. Sir, if you can hear me, please disconnect one device as you have connected two devices. Durasamy sir. Sir, can you hear me? पवितार सिंह सर। पवितार सिंह सर।
जी।
सर आप किसी आइटम में आर्ग्यू करेंगे?
सॉरी,
आप किसी आइटम में आर्ग्यू करेंगे सर?
आई एम
आप
सॉरी।
किसी आइटम में आप किसी आइटम में आप आर्ग्यू करेंगे सर?
जी नहीं, आई एम
तो
सॉरी।
सर आप बार बार कैमरा क्यों स्टार्ट कर रहे हैं सर? रिक्वेस्ट है, आप कैमरा मत स्टार्ट करिए बार बार अपना। थैंक यू। थैंक
Apologize
यू।
and won't
थैंक
do
यू।
it again.
थैंक यू।
My lord, under accompanying circumstances, I am mentioning one urgent matter. Matter belonging to Andaman Nicobar Islands, my lord. Petitioner is working as a assistant professor. Tribunal has allowed the original application. The High Court, in terms of the latest decision of the Supreme Court, my lord, the High Court not only set aside the order of the tribunal.
Which case are you arguing, sir? We have not called upon you, you have started arguing.
My lord, kindly please fix the matter on, phrase matter on Monday, my lord.
We will see. What is it? We will see, examine urgency, then we will decide.
With your lordship's permission, may I mention a matter, your lordships? The HPC and Supervisory High Powered Committee, the High Powered Committee and the Supervisory High Powered Committee of the Maharashtra, your lordships, they have dismissed my nomination, your lordships, as a candidate to election on the pretext that I hold
For
as
bar
president
council election.
for bar council.
Very good, very good.
Your lordships, it is for the reason that I am president of the bar. Your lordships have already passed that order that
File an
rule
election.
is violated.
You must remain busy throughout the year.
Your lordships have already passed the order. May I just pass this order? Your lordships have already passed.
That's what I.
Yes.
Yes.
Your lordships have already passed this
You
order.
can also rely upon if the order is already there.
The issue is the Bar Council of India has not amended this rule, your lordships. Your lordships has already said then the office bearer cannot be the it cannot be an hurdle from contesting an election. Now I am the president of a bar association. Only because
Consider the direction is already there. Once this rule is revisited by them, it will apply uniformly to you also.
yes, so as of now they have not amended this rule. So therefore my candidature is now cancelled. your lordship.
Let them have some breathing time and then they will.
Your lordships, I have filed the SLP. If your lordship will direct the SLP to be listed tomorrow, your lordships. Yesterday, the supervisory high powered committee have rejected my candidature.
Well, we'll see whether your matter is listed.
Item 2, my lord, is early hearing application, my lord. Item 2, we have filed early hearing because there is stay order which is operating and 550
Early ring in what?
of appeal, my lord.
Which item?
Which is admitted in item 2, my lord.
Number 1%. To entertain early hearing.
That's the only reason I am mentioning, my lord, because insofar as that stay order which is passed by this court has resulted in a stay order around 550.
We will examine ourselves. We will examine those matters.
Please, my lord, may kindly. Please, my lord.
If I may mention,
I mention, Lordships, I am the chairholder of the Secretary of the Bar Council of Maharashtra, State Bar Council. I am lying on the similar footing, Lordships. I filed my SLP today. May it be tagged with together and listed tomorrow, my Lordships. If you
There
can.
is no question of listing tomorrow if you have filed it today.
Lordship, the urgency is that the Bar Council of Maharashtra is contesting the election of 24th of this month, Lordships.
Let it be. You should have come earlier.
Your Lordship, if I may mention, this is a fresh SLP I had filed on Monday. An urgency letter was moved. There's an exemption from surrender that was filed.
So
The-
filed on Monday.
Yes, Your Lordship, it's not listed. It's listed. The tentative
No,
list is showing for
Filed on
Monday.
Monday. Have you cured the defects?
Yes, Your Lordship, the defects were cured and exemption for surrender also filed. An urgency letter was moved, but the date is showing as Monday, even though the petition has to surrender by Sunday. The stay that is granted by the
Just
imperial order
examine
is
what is-
pending.
Give the particulars.
Your lordships, I'm sorry, your lordships. The election petition matter, I just mentioned your lordships. Yesterday, the order was passed. Yesterday, the high powered committee has ordered passed.
Very fine, very fine. Not before Monday.
Your lordship will have it tomorrow.
No question of listing tomorrow. There is nothing.
Then your
it is
lordship
not
will
going to
have
pass.
it on Monday, your lordship.
Item 8.
Obliged.
My lords, item 8, we had circulated a letter to bring the counter affidavit on record. However, it was not taken up on record because of the fixed date of existing.
Bail application, how much time do you want?
My lords, we filed our counter affidavits not on record. My lords, we have it next week.
You have filed the counter affidavit.
We have filed the counter affidavit.
Then state council informed that counter affidavit has been filed. The same is not on record. Registry directly to tag the same paper book. Post the matter on next week.
Grateful, my lords.
Please, my lords. I have surrendered.
Take the list of matter.
Two, Lordship's order of 24-2, I surrendered on 26-2. Because I was applying for anticipatory bail, my lords. It fell from your lordship's surrender. We will consider. Therefore, my lords, on 26th itself, I surrendered. Charge sheets are filed, supplementary charge sheets are filed, everything is filed.
My lords, we have sought for police custody
How can you file, after filing charge sheet, where is the question of police custody? This is some new law.
In the course of further investigation, for an accused who was not available, he's now been arrested. We've sought police custody. He's filed his opposition to that police custody. The learned magistrate has to consider it, and orders are reserved already. So the police custody remand will have to first be considered, is our submission.
The order has been reserved on that.
Reserved
I'm praying, my lords.
as of yesterday.
My learned, I'm praying when it came up for your lords, before your lordships, my lords, the first time, this time on 24th, it fell from my lords that instead of staying in Sri Lanka, I better surrender and I come here. Then your lordships may consider my prayer for interim bail and bail, which I did within 2 days. I gave an undertaking, I will come back, and I did that.
So let us see first of all what the court decide about your custody.
It doesn't lie. I mean, after charge sheet supplementary, under which provision will it be
They can
provided
file
for,
a
my lords?
supplementary charge sheet, Mr. Dave.
You can make the submission before us.
No.
Under which provision?
Yes.
We expect that you would be knowing the provision.
After filing of charge sheet,
Yes, after the filing of charge sheet.
for a police custody,
Yes,
grant.
sir.
No, my lords, both
This court is held.
both
Go back
Kaskar,
and read Dinesh Dalmia.
yes,
Dinesh
Dinesh Dalmia and Kaskar, my lords. I have read Dinesh Dalmia, my lords. Lordships may take it that I have read it. It is for an accused who was absconding, for which further.
You were absconding, you had a lookout
I
notice.
was before your lordships, my lords. That's why this order came to be passed.
For us, you came much
Look,
late.
that's why this order came to be passed, my lords, that it will be, your lordships may consider regular bail, including interim bail.
Very good.
Now,
But in fact,
and-
now that he
and
has
consider
surrendered,
this.
the
I
normal
surrender-
course should follow.
We are informed that after that the petitioner has surrendered in terms of order dated 24th February 2026, and thereafter his full police custody has been sought. The orders, thereafter on the issue of a requirement of petitioner's custody by police for interrogation, the matter has been argued before the judicial magistrate and the order is reserved.
Please.
Next. Let us see what.
Lordship, please.
I am obliged.
Next week.
Your side, 10 similar matters are pending before your lordships with regard to this West Bengal SIR.
Every day, okay. Why people are filing and,
I'm a MLA from West Bengal, so
you had to know new paragraphs and
the main matters are coming up on 24th of March.
whatever date is coming.
Let this be tagged along with the main matters, my lords. Let this be tagged along with the main matters which is coming up.
What we have done.
24th.
We have done it. We have done that. Oh, आइए. गुम हो गए थे. आप तो रोज ही कोर्ट में खड़े रहते हो. आप मैंने कहा पहुंचाने में देर लगी. आपको कहाँ थे आप?
No, I practice in Lucknow, so that I don't know the.
नहीं, आप आते रहते हैं.
Sometimes.
आप नहीं आते तो हम बुलाते रहते हैं.
Sometimes I dare to come to the Supreme Court. But the
Yes,
order,
please tell us.
the order passed by the High Court. Order passed by the High Court through which my petition claiming ₹1 crore as a fee and expenses for filing the 6 cases to defend the then Honorable the Chief Justice, Honorable Sri
But you
Deepak
have been
Misra.
arguing in person, so you have not incurred any expenses.
The expense was at least 2 lakhs. And at that time, I was my entry in the High Court was prohibited, and so that I took this money from my daughter to defend to file the cases and until the motion was not rejected by the chairman. I didn't file any petition except on the seat on which Lordship is sitting, Honorable Judge Deepak Misra was sitting. I made at least 15 mentions for his Lordship for getting the defect removed
after making left and right all kind of allegations, why you are using the word honorable now?
My lord.
Where did you left the definition of honorable now?
My lord.
After making all kind of nasty allegations against a sitting judge at that time.
My lord.
Now you are.
No, yeah, my lord, what I'm submitting is,
Huh?
I was submitting it that my lord, the judges cannot address the press conference against the Chief Justice, and this was against the norms. In case he would have been some IAS officer, some any other officer, you would have dismissed from service immediately.
Mr. Pandey, you provided social service to the institution.
But even then I am having a stomach,
You
my lord.
provided social service to the institution,
Mal.
and for social service is always priceless. How can it be assessed as 1 crore, 2 crore, 3
My
crore?
lord, I have to pay some cost to the Supreme Court. My lord, one day, and you have the order passed by Supreme Court. I was picked up from my house at
Cost of
blood for recovery of cost of rupees 1 lakh. I was picked up at 8 a.m. when was doing a prayer in my house, and they left me when the recovery of.
that we are aware. You have lot of litigation in your family, and some persons are there. Lot of FIRs, cross FIRs. Those matters have been coming before us. Those have nothing to do with the petition which you filed with respect to the alleged rescuing of a judge. That you have done a social service. You want an appreciation. We appreciate for that, and you continue to do your work. Thank you very much.
Please, Kali 1 minute, Kali 1 minute, page 135, please see the order on the ground of which my reference made by the president has been rejected by the law ministry. I am permitted to read that. Please see, that. Please say that ground, on page 135, please,
Yes, read here.
Payment of fee and expenses for filing 5 cases to save the Honorable Judge Chief Justice Deepak Misra from torture, insult, humiliation, and removal. Regarding, sir, please refer to your undated letter concerning of the subject mentioned above, which the department has received from the Department of Justice according to their office memorandum such and letter through the President Secretariat as per the letter dated such. Regarding the matter, it is important to note that the government of India has an extensive, exclusive panel of advocates at the Supreme Court of India to represent the government interests, and that you are not included in the panel of this department as the Supreme Court of India. When this petition was, when this impeachment proceeding was going on and the Chief Justice of India was being insulted, neither the Attorney General came forward, nor the Solicitor General came forward. And this government of India is saying that we are having extensive panel. Please kindly consider. In case I moved the application for the initiation of the criminal contempt proceedings against Mr. Kapil Sibal. Please permit me. In case Mr. Sibal, the Attorney General would have granted that permission to prosecute. He himself would have started prosecution. The impeachment motion for removal of the Honorable Justice Deepak Misra would not have brought. But it started when the application for filing the criminal contempt was rejected by the Attorney General. The government is saying, they are saying that you have not done anything. Plus, suppose that I am doing something, and in lieu thereof, some public servant, and top-ranking public servant is being saved. The appointing authority of the Chief Justice of Bharat is the President.
We have heard the petitioning person at a considerable length. The claim which he put forth before the High Court and which has rightly been rejected, is totally misconceived and misdirected. No case to entertain this specially without dismissal. That's both of you. Thank you.
That is the cost incurred in my. At least I am having also.
Thank you very much. Continue to render your social services. That's all.
But for that the funds are required.
Thank you.
Obliged.
Please, my lord. My lord, the petitioners are all farmers whose land was acquired, about 1,000 acres, between 1994 and 2000, and given over to a private company with the stated public purpose of creating an industrial hub, a thermal plant, and a chemical plant.
Compensation then, if you are challenging.
Not all of us have received compensation. There's part
Finance
compensation.
compensation was paid in 2017. If it is not paid, that can be pursued. And Madam, see paragraph 143. Your interests have been protected by saying that one from every family will be given employment.
That has not happened, Lordship, because there was.
It's not happened, Madam. The answer is a contempt petition, not an SLP before the Supreme
Lordship,
Court.
if I may just clarify that, the industrial project is now being shelved through a share purchase agreement. It's been given over to a builder.
Follow it.
So
If
then
that is so, then there must be a recall or modification of paragraph 143.
My lord,
What the High Court held was the share purchase agreement, however, is subject to the terms of the MOU and it will be treated to be an industrial undertaking.
Lordship, on the contrary, they have the impugned order goes beyond the MOU.
Understand?
If Lordship will.
We understand what you are saying, but the thing is, ultimate directions, you see, there is some confusion in reasoning.
Lordship,
Section 41 of the Land
and
Acquisition Act has been ignored.
I'm obliged.
Right, but ultimately what the High Court does is to your advantage.
Lordship, if Lordship will just have para 89. There's wilderness, Lordship. There's a jungle growing. Out of the 1,000 acres, 400 were later denotified. So it's about 600 plus acres, out of which 98 has been developed somewhat. The rest is wilderness.
Are they developing as a township? Or they are developing as a chemical plant?
Private builder, Lordship. Private builder for residential purposes.
Only for residential.
Only for residential purposes.
Land has gone for procuring. See, is somebody colluding in government? Well, some politician must have colluded with this builder.
We would be very eager to give a notice if PODA had come before us.
Lordship, I cannot
That is
be
why
made
we
to
were-
suffer for Pudas. They were there in the High Court. They also filed a review.
That is, they cancelled it.
Issue notice.
I'm very grateful. Would Lordship consider granting status quo on the land because there will be alienation?
According to you, they are not doing anything on this spot. In 1 month, what they will raise there?
Let there be status quo, Lordship, because if there are further alienations, then I will suffer.
Meanwhile,
You
no
will
third party
suffer,
rights will be
madam. You have no right on the land. At best, you might have some more enhanced compensation.
Lordship, I will pray for.
No threat.
I'm obliged, Lordship. I'm very obliged.
Please, Your Lordship. Lordship, in similar matters, my lords have given direction to approach to the competent authority. My lords, but there is one issue which I want to raise before my lords. My lords, kindly turn to page 68, my lords, of order input, my lords. Page 68 number.
Whatever issue, additional issue you raise, that also.
No. I am not. So, sir, I am not raising any additional issue, sir. Sir, actually, there is a direction given by the High Court that actually we are not inclined to interfere in the matter because there is undertaking given by the government of Rajasthan to hold the election prior to 15th of April 2026, my lords. But, my lords, they are not holding the elections as of now, my lords. And they have approached again to the Honorable Apex Court, my lords, for extending the date, my lords. They are not holding the elections, my lords.
Please appreciate if the High Court direction for conducting election in a time-bound manner is not being honored. For that, you
My-
can go to the High Court with a contempt or whatever action you want.
No, sir. Sir, they have given undertaking before this Honorable Supreme Court of India, my lords. Honorable Supreme Court, they have given undertaking, my lords. It has been mentioned in order input, my lords. It is very well mentioned, my lords. Page number 68, my lords.
In any case, in the matter where this undertaking was given, you can take action as per that.
My lords may given the my lords, it may be given direction. I will take appropriate action. My lords. They have given undertaking, my lords, before my lords. They have given undertaking, my lords, before Honorable Supreme Court of India.
No, in which matter it was given, that in that matter you can take appropriate action. We are hinting you.
Sir, our matter was not heard on merit by Honorable High Court, my lords, for the reason that we are disturbing by filing these petitions. That's why they have given a specific direction because you are disturbing. The actual elections are to be held prior to 15th of April.
Next paragraph. Land counsel for the petitioner has also pointed before disposal. Take one more paragraph. Counsel for the petitioner has further pointed out the operative part of the influence judgment of the High Court, where it is mentioned that the authorities had given an undertaking before this court to hold Gram Panchayat elections by 15th April 2026. It is stated that no process for conducting the elections has been commenced so far. So that is so, the agreed parties shall be at liberty to seek redressal of their grievances in accordance with law.
Obliged. Deeply obliged.
Exporting.
Please, Lordships. Lordships, High Court rejects the nomination made by the petitioner, and that nomination, my lords, High Court directs me to select me from the panel curated and controlled by the respondent, which is contrary to the judgment of this Honorable Court in the Constitution by Judgment Core. The same issue, my lords, High Court relies on Vilupuram Highway's judgment.
You are also adamant that you want a particular bureaucrat as your arbitrator. Why couldn't you request to the High Court that all right, High Court can appoint some independent arbitrator?
My lords, that was, my lords, but they are forcing me to select us from.
They are forcing, you don't want. You are also forcing them to, you are a handpicked person who is a former bureaucrat.
That is the mandate of the contract clause, my lords, 38.3.
There is no question of contract. Then go for contract. Why are you coming to court?
The mandate of the contract, you go into the Sarod rules.
My lords, the Sarod rules issue, my lords, is pending before a bench of this Honorable
You have
Court.
enough money to spend on litigation, frivolous litigation.
My lords, I understand.
Instead of, you could tell the High Court, I am not accepting their arbitrator.
Lordships.
They are not accepting my arbitrator. You please appoint someone independent person.
But by forcing me to go for Sarod, my lords, I am being forced to select an arbitrator from.
Retired High Court Chief Justices, retired Supreme Court judges are in the panel of Sarod. You have seen the nomination made by your respondent.
My lords, the entire issue therein, my lords.
To nominate here.
My lords, the High Court has relied on a judgment this issue regarding the validity of Sarod panel, my lords, is pending before this honorable court, my lords. The same issue, my lords. They have relied on Vilupuram Highway's judgment.
Pending, sir.
My lords,
It will
this
be
will have.
decided there, but if, in our estimation, the standing and the stature of the members in the Sarod panel completely dispel any doubt of curation.
My lords, but the Sarod panel, my lords.
That's what we are saying.
The Sarod panel, my lords.
You want an arbitrator of your who is in your pocket, that's all.
My lords, but then send it back to the High Court.
Let
Let us
so
appoint an
much
independent
again.
arbitrator, my lords. We being forced to appoint a Sarod panel,
Yes,
which is
if you want
curated.
to appoint
My lords,
a-
Sarod panel, my lords, a panel which is curated by the respondent corporation, my lords, that is specifically been disapproved by the constitution bench of this judgment of this some particular court, my lords.
Number of judgments.
Para 168, my lords, of that of the court judgment, my lords, specifically disapproves because they have relied on hostile pine judgment.
There is no deep pervasive control of NHAI on Sarod. And again, we are reiterating, sir, the stature, the reputation and the respectability of the members in the panel are absolutely above board.
It's identical.
Para 37 of the Act.
Yes, my lords, I've seen my lords, para 37, my lords, I bowed down, my lords, para 37, my lords, may I have para 36 for a moment, my lords, para 36.
You read 37.
Yes, my lords, para 37, my lords,
Yes.
I bow down, my lords, I've seen that para 36 is the operative part, but just prior to that, they draw reliance from para 36 of the judgment in Vilupuram Highways, my lords. For a moment, my lords, page 18.
Ignore Vilupuram. We ignore Vilupuram. Again, we are repeating to you. Nothing is straitjacketed. When it's a question of bias, when it's a question of equality of arms, it is to be seen who is the arbitrator concerned. And if the arbitrator concerned has a reputation of standing before a section 11(6) court, we have no doubt that there is a question of bias.
My lords, Vilupuram, my lords, specifically, my lords, they have relied.
Vilupuram will be decided.
My lords, they have drawn, my lords, they have drawn in the reliance from Vilupuram Highways. My lords, I see para 36.
This institution of arbitration is being destroyed and with the active support of the lawyers and some the arbitrators who are.
May my lordship's attention, my lords, to draw lords para the clause 38, my lords, of the arbitration clause.
If these were not acceptable, you could request the High Court that well,
Yes, my lords, may I send it back to the High Court for considering that, my lords, so that we can have an independent arbitrator. My lords, we are being forced to select an arbitrator from the panel.
There is nothing like
clause 30. My lords, clause 38.
Party
Sir,
autonomy,
there is no force.
Party autonomy does not mean that you keep a pocket your arbitrator and say that this is the person.
That is exactly what we are saying, my lords, because they are selecting.
Also too.
They are selecting from the panel. They're forcing us to select from their panel. My lords, clause 38 says we'll nominate an arbitrator. They will nominate an arbitrator. The third arbitrator will be according to Sarod rules. But High Court says no, everything has to be done according to Sarod rules. Even the first arbitrator is to be appointed by the Sarod rules.
In an arbitration dispute with the National Highway Authority of India, the petitioner contractor wanted to appoint a former bureaucrat as the arbitrator, as its nominee arbitrator. NHAI did not accept such nomination. The matter nomination and requested and insisted for appointment of an arbitrator out of the panel of arbitrators maintained by the Society for Affordable Redressal of Disputes, in bracket Sarod. The petitioner objected to the nomination of arbitrator from Sarod panel and consequently approached the High Court. Its writ petition has been dismissed by the impugned judgment. We find from para 37 of the judgment under challenge that the Sarod panel is a broad-based list of empaneled arbitrators that include former Supreme Court judges, former High Court judges across several states, retired secretaries to Government of India, members of the statutory body such as NHRC, senior engineers, financial experts, and other professionals of high repute. In light of this, it is totally misconceived and misdirected contention of the petitioner that it is being compelled to directly plead that the part autonomy is being compromised. In any case, nothing precluded the petitioner to request the High Court to appoint some independent arbitrator of the High Court's choice. We therefore see no reason to interfere in the interim judgment of the High Court. We have our grant liberty to the petitioner to move an application before the High Court. Some independent arbitrator from panel and or otherwise, as per the choice of the High Court, may be appointed.
Is the arbitration clause is thorough or any other arbitration rules applicable?
That's what you have said. We have said that we leave it to High Court.
Thorough part, because we may appoint from the High Court panel, my lords.
We leave it to the High Court.
Wait, please, my lords. Wait, please, my lords. My lord, this petition is related to the UGC regulations, which is already in the consideration of this honorable court. But this PIL is fundamentally distinct from those writ petitions because those primarily focus on substantive definitions of 3C, while this present petition has primarily focused on procedural and enforcement architecture. My lords, it was filed on 13th of January. It was
Yes, I have the order.
Direction to give short court.
obliged, my lords.
May it please your lordships. Lord, this petition is challenging the constitutional validity of Section 129 of Transfer of Property Act, as well as Section 2 of Shariat Application Act 1937, so far as the word gift is concerned. Lord, the scheme that has been laid down in Section 129, the conclusion, the repercussion of that is Muslims are exempted from paying stamp duty while non-Muslims are not. Other than that, my lord, this particular section, since registration is not mandatory for Muslims, it also causes uncertainty in land records as well as in litigation as well. Lord, may kindly have Section 129 for a moment.
What is your problem? What is your problem with 129?
Lord, the grievance here is that by virtue of
for any exemption.
No, Lord, by virtue of Section 129, read with Section 2 of Shariat Application Act.
Except you are saying that there is a loss caused to the public exchequer.
That's one point. But here I'm challenging it at the threshold of Article 14 and 15 also. Because by virtue of this, when we read this conjointly with Section 3A of...
First of all, if there is a loss to the public exchequer, what prevents Parliament is the competent forum. Parliament can always amend the law.
Lord, that's
Parliament can bring a new law. Parliament can amend the law. Parliament can suitably modify it. Whatever way they want, they are the competent authority. They can do it.
Very well, Lord. But my grievance here is that by virtue of this section, Muslims are exempted from paying stamp duty, while the same favor or same exemption is not granted to non-Muslims. When we read this, when we read Section 129 conjointly with Section 3A of Stamp Act, as well as the Section 17 of Registration Act, my lord, since registration is not compulsory for them, consequently, they are not liable to pay stamp duty. Hence, the lost cause to the exchequer is my third point.
For Mr. Consul, what prevents you? First of all, you should have gone to, why didn't you represent a single parliamentarian pointing out to them that look here in the law, which is pre-constitution, there is some element of alleged discrimination as you are proclaiming, and therefore you bring to the notice. You sensitize them. They are public representative. They will understand what is wrong and what is right.
Not the answer to that question is there is an interplay between Transfer of Property Act, Stamp Act, as well as the Registration Act. Because of that interplay, this honorable court may decide this dispute, because unless that
when the matter involve amendment of a provision, striking down of a provision, what prevents you and why have you not chosen to approach those parliamentarian who are competent, who can take up this issue?
Because, my lord, the clash between personal law and fundamental rights, so far as the concept of gifts is concerned, has to be determined by this honorable court. Not there is an interplay between these three legislations, and this situation has needs to be.
We will determine only when somebody shows bona fide. First of all, approach here and there, you knocks all the door, and when you find that you are not getting 1882 law, suddenly in 2026 you have remembered that it violates Article 14, and when you remembered it, you didn't deem it appropriate even to inform those persons who are the best one to rectify it.
But not by virtue of section Article 13(1). This I'm relying on that, because this both of them being pre-constitutional laws, they are already hit by Article 13(1), and they are void to that inconsistency. Hence, my lord, I approach your lordships for this.
So therefore, what prevented you, first of all, tell why have you not approached anyone?
Lord, because
coming after 75 years of independence.
Lord, I'm 30 years old.
2026. Please tell us. Every day the PIL.
Lord, the problem here is that
to approach someone.
Lord, there's one problem. The personal law, the clash between personal law and fundamental rights here, as so far as it pertains to gifts not being an integral part of the.
Right now, commenting anything on the merits. That is, you are apprehending that the plea of personal right, personal law, any XYZ will be taken. We are only on the peripheral issue at this stage, that suddenly for challenging on a fine morning you find that this law is offending certain provisions. So what prevented you at least to inform the lawmakers that look here, this is one provision which might have escaped your notice. This is a provision which probably required to be revisited by you.
Very well.
The reasons, maybe they agree with your reason. Law Commission. Best for me, Law Commission. Every day, the Law Commission make recommendations for suitable changes, bringing new enactments. There you could also represent.
Very well, not, but so far as this intertwining between these three
it does not come in the news. That is the problem.
No, Lord, that's
that is the biggest problem.
That's not my motivation, Lord. I have 7 to 8 years of practice, Lord, as officer of this honorable court.
Counsel, you are right, but the thing is, when you see 129 and 123, you have to examine it both from the end of the donor and the donee.
Very well.
Right? So, if you see from the donor's point of view, you are making out a case of discrimination on the point of religion. But a hiba is not in respect of a donee, religion specific. It can be to any other faith or a person who is a non-Muslim. So if that is so, when the donee is a non-Muslim, whether the hiba being carved out of as a special species of gift and non-registrable will be a reasonable classification or not is to be first examined by the Law Commission.
No, there is no intelligible differentiate there. The reason why I say this, one, the concept of hiba is 1400 years old, when there was no system of registration or anything to be reduced in writing. And two, my lord,
foremost, you are making a fundamental error. It is not 1400 years which is relevant, but hiba, even in respect of an immovable property, can be by way of an oral declaration.
But Lord, that would the repercussions would be massive. For example, Lord, may I
one thing at a time. The question you have posed is one of religious discrimination. When the donee does not have a religious identity, can the hiba give to someone else be identified by the religion of the donor? This is one question. The second question with regard to your loss of revenue is a matter of classification where an oral declaration or bequest is kept apart in contradistinction to written instruments which require registration. This is a reasonable classification. Thirdly, if you see the other area of vexatious transfers which do not get recorded is again not something that will make the law manifestly arbitrary, but may require some noting or some recording of an oral declaration, which is for the legislatures to see. So please approach the Law Commission. I think the Law Commission is the best authority to look into this.
So the petitioners have approached this court invoking jurisdiction
Lord, then
Article 32 of the Constitution, with a prayer to strike down the words inverted commas or shall be deemed to affect any rule of nominal law inverted commas closed occurring in section 129 of the Transfer Property Act 1983. The plea taken is that exemption of a gift as defined in section 2 of the Muslim Personal Law in bracket Shariat bracket close Application Act 1957 from the requirement of compulsory registration and consequential non-payment of stamp duty charges is not only a loss to the public exchequer, such provision does not meet with the mandatory standard of Article 14 of the Constitution. So, in our considered opinion, the appropriate recourse for the petitioners would be to approach the expert body like Law Commission of India, who have been entrusted the responsibility of recommending suitable amendments, stroke changes in the existing laws, and of enactment of new laws, as may be required from time to time. Such an expert body being functional as of now, we see no reason to entertain this requisition at this stage. The same is accordingly disposed of with liberty to the petitioners to approach the Law Commission of India.
grateful, Lord.
Lordships, I am suffering from inordinate delay, judicial delay caused by the Honorable Bench of Lucknow, Honorable Allahabad High Court. So since last 13 years, my matter is not reached, not taken up. So many times I mentioned application, mentioned the case and listing application, but there is nothing in my hands.
matters are listed before one judge in that High Court?
Lordship, 13 years.
Look at the human beings, their conditions also. How much burden you want? It's not that we are not aware. In one or two matters, if we have put a word of advice, that does not mean that we do not know the amount of work they are performing.
Lordship, we are also aware, but it's a 13 years delay.
13
13 years.
Matters are pending from 20 years, then why 13-year-old?
That is why, and this matter is of recruitment
Please
issue.
tell us.
My
What is the oldest
age is
matter
going
here?
to be finished. My
What is
age
the
is going
oldest
to be
matter?
finished too. Yes. Kindly give me some opportunity to be heard before Honorable Court.
That's right. It is not the question that we want every case should be disposed of within 6 months, within a year. Given a choice, we would like to have that kind of situation.
Lordship, I have no recourse to come before this Honorable Court. Where I can go? Because
you have
lots
come?
of time I've entered the Honorable Lucknow High Court. So many applications, so many mentions, everything I have exhausted.
One case out of track and ask the High Court to dispose of it on early basis without the turn having come. What will happen? This disposal will be at the cost of one or the other person who is sitting in the queue and who definitely does not have mean to come Supreme Court. You have means, that's why you are before us.
Lordship, it's a selection issue. It's a selection issue. My age is going to finish and then I can note. And I'm an army man family and I'm trying to my best to be serve myself as an army officer. So it's a teacher recruitment issue and my interviews were done, but the merit was decided on the sole basis of interview, not the written examination.
Concerned on merits because the issue is not before
Let's see. That is, I requested to this Honorable Court. Kindly give me direction to the Honorable Court.
The instant petition has been filed seeking a direction for early disposal of a petition pending before the Allahabad High Court and Lucknow bench. This kind of petitions are filed routinely, and this court has been extremely reluctant to entertain the same. Though such like petitions are filed routinely, this court has been always reluctant to entertain the same. The roster management of the High Court has to be left to the prerogative of Honorable Chief Justice of the High Court. It is pointed out that the petitioner is unemployed and his case for appointment of a religious teacher in Molvi in the Indian Army is pending consideration since 2013. All that we wish to observe is that the petitioner may move an appropriate.
Lordship, pleadings also are completed in this matter. Pleadings are also completed in 2013.
May move an application before the High Court along with a copy of this order. We request the High Court to consider the petitioner's prayer for early disposal of the case sympathetically. However, as per its own prerogative and discretion.
Oblige, my lords.
Yeah, please, my lord. Petitioner belonged to the PWD category, my lord, and he had applied for the post of civil judge in the state of Rajasthan in the year 21 and 24 under the said category, my lord. And he had qualified the mains exams in both the occasions, but he was not called for the interview. He had the minimum qualifying marks, and in the under the said category, and in the year 2021 advertisement, my lord, there were 5 seats reserved for the PWD category, but none were filled up. And in the year and none were called for the interview. And in the year 2024, there were 9 seats under the said category. Only 3 seats were filled up. Six remain vacant. And those 3 candidates were approached this honorable court, and on the direction of this honorable court,
those who have been going to the right forms and seeking rightly intervention, they have got the relief. This man has been, poor fellow has been.
No, my lord. No, my lord, this is not so, my lord. My lord, in fact, he was proactive. He had approached to the High Court, though the other candidates approached this honorable court. And at that time, he was not aware that this honorable court has appeared. Only when the final result came and the cutoff list came, cutoff of the final result came, then he came to know that.
Is already over. He has not been harassed by High Court, he has been harassed by his consuls who have been misguiding him and putting him. 2022, when the matter was decided, why he should have come to the Supreme Court. 24 again, then come to the Supreme Court. The others came and got the relief.
No, my lord.
Selection process is over, everything is over.
No, my lord, what has happened in the year 2022, he approached the High Court. His petition was pending, therefore he could not come to this honorable court. As far as the 2024 advertisement is concerned, my lord, mains result came on 1st October. The timeline is very important, lord. On 1st October 24, mains result came. He did not find his name in the said list. He immediately, within 5 days, on 6th October, he filed the writ petition before the High Court, and the High Court dismissed his writ petition after 10 days, that is on 16 October. And
just in Nagaratna.
Sir.
Page 9.
Page 99, annexure 11, my lord.
Started on 15th April 25.
Yes, my lord.
146. Let this petition be listed before the bench presided over by Justice. Mention my name of my sister, Vivi Nagaratna, on Monday.
Just
Much obliged.
Grateful, my lord. Grateful.
Item 19, there is a letter circulated.
My lord. Much obliged.
Yes, item 20.
Please, Madam. No, the petitioner is retired Lieutenant Colonel, selection grade. If I may point out, my lord, so far as selection grade and the time scale is concerned, by length of service.
Why can't you go to AFT? Because it is time barred, unfortunately.
It's not. I'll explain, my lord, if your lordship.
So you claim it is time barred
Your
because
lordship is right. In fact, I also suggested my client at the threshold that he should be approaching the.
You can still make out a case before AFT.
Yes.
Saying that it's a recurring cause of action. And therefore, if the AFP, first of all, we hope that they will appreciate this part, because pensionary claim normally is an recurring cause.
Please, my lord.
But at least give us also some face to that we can interfere if you come through some channel. Directly, it may not be. Please.
Please, your lordship, don't mind, my lord, please. Looking at, just a moment. My name goes missing. Page 64, your lordship will have. Page 64 for a moment, my lord.
Directly entertaining a repetition, you know very well with your experience, it may not be advisable.
Then your lordship will allow me to approach the dragon.
We will not allow you, we will say something that you can take benefit of that.
Your lordship will have then page 64 for a moment, my lord. The table at the top, if your lordship.
We will say, write down, the petitioners are retired officers of the Indian Army. They lastly held the rank of Lieutenant Colonel in bracket selection grade. So it seems that an anomalous situation has arisen in the matter of fixation of pension. Which, according to the petitioners, is contrary to inverted commas one rank, one pension scheme. We are however of the view that this is not a matter which should be entertained directly under Article 32 of the Constitution, when the petitioners have got an efficacious alternative remedy to approach the Armed Forces Tribunal. The petition is accordingly disposed of to the liberty to the petitioners to approach the tribunal in accordance with law. As regard to the point of limitation, we do not express any opinion in relation thereto, except that the petitioners, if so advised, may plead recurring cause of action. We are trying to hint to the tribunal to entertain that we can, this much only we can do, recurring cause of action. The rest we leave to the AFP.
Yes. Lordship may say AFT principal bench. Because it is pan-India, so let it be here only.
You will go and you will find the matters are not taking much time there. And to the liberty of mention, the petition disposed of at this stage.
Please, Your Lordships. The Lordships, in this case, my lords, they are pursuant to the allegations of complaints received regarding corruption and the misconduct, my lords.
Right now.
But, Your Lordships, the penalty that was imposed was the leave of the kind due. We have considered his representation as considerably as we could, my lords. We've given him the benefit of all his leaves.
Principally, we might agree with you. We are with you. But leave it there. Whatever has it.
But, Your Lordships, there were 4 complaints, out of which in 3 complaints, the inquiry findings were against him. Major penalty proceedings were proposed.
There were complaints and complaints.
Please, Your Lordship. Yes. Yes, Your Lordships, they were there.
But then,
my lords, and major penalty proceedings, the stage was that. And my lords, then we went under that rule and prematurely retired him. This is the least that he can do, my lords. He must return this money.
it's all right.
As Your Lordships, please. Obliged.
We have heard Senior Counsel on behalf of the Petitioner High Court at a considerable length. in the peculiar facts and circumstances of the case, we are not inclined to interfere with the employee judgment of the High Court.
Your Lordship. Item 22, Your Lordship. Your Lordship, once a land which is recorded as a forest land, my Lord, it cannot be, my Lord, converted into something without.
So have taken unauthorized possession there of the land.
My Lord?
You must have grabbed this land or
No.
persons on their behalf you are fighting.
No, my Lord.
You should have something at least for these, those who have sacrificed their life for the nation, at least have some respect for them.
My Lord, we are
have
respectfully
seen thankless
submitting
people like this.
that, my Lord, this land is not being in fact purposely used for that
What has
purpose
this been
also, my Lord.
cost? The High Court has dealt with the right of the High Court has dealt with the petitioner lightly by merely by merely dismissing the writ petition. A person who has no respect for the
Your Lordship, may I humbly submit, my Lord?
the war heroes who made supreme sacrifice for the protection of the borders of this country, should not have been allowed even to entertain, should not have been allowed to enter the High Court premises. And in any case, he should have been burdened with exemplary posts. We issue show cause notice to him, let him come and explain. And we will hold an inquiry at whose instance he is filing this petition.
My Lord, may I humbly submit, my Lord? His grievance is that war memorial is also not being, my Lord, properly constructed there, my Lord. It's being, my Lord, illegally, my Lord, misused, my Lord. See my pleadings, my Lord.
This is all mischievously designed writ petition.
My Lord, petitioner is, my Lord, a practicing advocate there in, my Lord, Dehradun, my Lord. My Lord, may see the pleadings, my Lord. He is saying that
you want us to, how much cost do you want us?
My Lord, with great respect, my Lord, I want, my Lord, this is SLP, my Lord, this order, my Lord. The legal provisions of section 2 was not considered. That's why, my Lord, we have filed this, my Lord.
Somebody who has vulture's eye on this land and somebody who are land grabbers sitting there, or he must be one of them, or his close relative, some family members must be there. That is how this all evil designed petition. As if we don't understand this.
My Lord, may plainly dismiss this as, my Lord.
Shame on him that you have problem with construction of a war memorial. You tell us what do you want.
My Lord, may dismiss it, my Lord.
Dismiss, then we'll impose cost also.
My Lord may not do that, my Lord, because legal, my Lord
has approached the court with dirty hands. A cost of rupees 1 lakh is imposed. You directed to deposit the same with the.
My Lord, with great respect, my Lord may not do so, my Lord. My Lord ask him to appear through BC, my Lord. I will ask him. He is also an advocate, my Lord. After hearing,
asking him to appear through BC.
My Lord,
why should we provide it in BC?
My Lord, imposing cost may not be a legal question was there that whether section 2, my Lord, can be in this manner, my Lord, be.
Anyway, choice is yours. Will impose cost of rupees 1 lakh.
My Lord may not. My Lord may then permit you to withdraw, my Lord.
No sooner we were dismissing the specially petition with exemplary costs. Common Land Council for the petition seeks and permitted to withdraw the same. Dismiss and withdraw.
Oblige, Lord.
Item 23, my lord. May it please this honorable court, I appear on behalf of the petitioners. My lord, your lordships have issued notice in 3 previous petitions challenging analogous provisions of this act. However, the emphasis of each of the petitions is slightly different from the other. So I thought, my lord, your lordship might like to issue notice in this.
We can hear all the matters together.
Yes, my lord, if your lordship can tag them.
Whatever is being raised, we can formulate another question when we.
Yes, my lord, it's a rather complicated act to begin with. The statute itself is new because it talks of data protection for the first time in the country.
Issue notice.
And
issue notice returnable on 23rd March, probably the date. 23rd.
You have the previous orders. These are the previous orders, my lord.
23rd March.
23rd March.
23rd March 26.
Each of them emphasize a different aspect of the act.
To be taken up along with recognition version and so on. When we will formulate the question, just point out so that
We'll do it. Milord, if I may briefly just tell you, the one is journalistic exception. Milord, public interest has been deleted from the RTI Act and also from the Data Protection Act. So therefore, a journalist cannot access data which is in the public interest. Milord, we concede that we can't have personal data. Journalists need not have personal data, but if it's in the public interest, for example, if you're writing about a public servant,
ultimately the interesting question that will have to be determined is what is public data and what is personal data.
Yes, my lord, that's a critical question. The Act doesn't clarify that. So therefore, my lord, it will require judicial interpretation. Exactly. And there is no definition of what is information and what is personal.
One interesting point can be whether a data with respect to a person, so long as he holds a public office, can it be termed as personal data or it will be treated as private?
Lord, we are also interested only in people in public office, certainly not private individuals who have a right to claim.
Madam, at the time of hearing, you will have to suggest there will be different hypothetical situations.
Yes, my lord.
And then probably we will be able to have a better analysis.
Well, Lord, not only hypothetical, but we can take cases that have actually gone to court under the RTI Act, where either the information has been allowed or disallowed, because these will be analogous provisions. Lord, in the RTI Act, there was an exception saying you can ask for information which is in public interest. That has been deleted from the Data Protection Act. Actually, that's what's causing the trouble. Otherwise, there would be no other problem. Then, my lord, the second is that the state has a right to call for any information. Of course, there are certain categories in sovereignty of the country, but they're overbroad. For example, they can call for information which is related to public order. Now, public order, as we all know, is a very broad category, my lord. It can include
but also,
anything.
Madam Indra, will request you to also suggest the measures to protect the individuals also. In a given case, if there are sweeping provisions permitting to have the complete information, and where the right to privacy and this conflict comes, then how to protect some individuals also?
Yes, my lord, the balance between the two, the balance between a person's private life.
So what can be the measures which can be taken without affecting the right to have this information?
Now, especially now, my lord, we have a right to privacy in this country. So that right also has to be protected.
That balancing, exactly.
Yes.
That is what you...
Between the right to privacy and the right to public information.
Precisely.
Yes, but this act does raise all those issues.
None of the right should compromise with the other, and none of the right should become an impediment in the effectivity of the right.
The doctrine of proportionality, overbroad, all those issues will arise for consideration by the court. And my lord, last but not the least, the state exempts itself from the provisions of this act. So therefore, we'll have to see that they can collect any data about us. There is a certain fear of surveillance also, which emerges from the reading of the provisions of this act, my lord. So we are hoping that this honorable court will give some direction, some enlightenment on these issues, my lord. These will be the four issues, my lord. Whether there is a danger of surveillance, whether the state can exempt itself, whether journalists can write about it.
One is the state collecting data, and there is another matter before us. We hope that it will proceed and eventually will decide on merits, where our entire data of the citizenry, not only of one nation, maybe a substantial part of the globe.
It's a global issue.
Global issue going into the very big private entities.
Yes, well, the question of data sovereignty arises. Data
becoming the real true wealth as on date.
Yes, there are provisions in this act, my lord, which enable them to access data from other countries also. So data sovereignty issues also arise. Lord, we are just hoping that this court will give us some guidance on all these issues.
It's a very interesting point, and we would like to, in any case, not only interesting, it's a very eminently required and an issue which deserves to be prioritized and determined.
Yes, my lord, your lordship will have to look at actually all the provisions of the act. My lord, one more issue. Earlier, under the IT Act, we had a right to get compensation if our data was illegally accessed. Now they've deleted that right to compensation if data is illegally accessed, and they've said the compensation, if any, will go to the state. It will go to the board. It will go to the data protection
Instead
board.
of the victim.
Yes, so that also will have to be. And my lord, one more thing, just for your lordship's information, the independence of the board. There is no judicial no judicial oversight into how the data protection board is constituted. My lord, your lordships have given judgments in Roger Matthew, etc., where there was a judicial oversight in how these quasi-judicial bodies are constituted. That issue is also there. Lord, I'll be happy to just frame a few questions and share them.
A tribunal which is meant to determine the rights of the people is bound to be a quasi-judicial forum.
These are the 5 issues, my lord. I can do the questions and submit for your consideration.
Yes,
deeply obliged.
These are complete, will formulate all.
We'll do. Obliged.
May it please you, my lords. Whereas I am appearing for family members who want to give a decent quietus to the ashes. Now just note 4 things, fellas. I am the grandnephew. I lived with the daughter. The daughter happens to be on the screen now, fellas. Please now. Supports this petition.
Many times this issue will come to.
So this is not that issue. That's the point it pains to make. No, Malad, this is not that issue.
Indirectly, directly.
No, Malad, no.
Timing also we understand everything, that why this petition is again coming after last year only we dismissed 2 petitions.
No, so therefore let me disabuse that. Let me disabuse. Your lordship.
First of all, where are the ashes, please? What is that proof? First of all,
yes, therefore, just let me answer my lord's query.
Where the entire family is saying that we are united on this.
So let me answer that. Number 1, the sole heir is the daughter who's alive at 84 now. She's on the screen now. Number 2, the family says this, turn to page 37. The matter that the lordship is hearing is to declare that he never died or he died. That's not the issue. So
that was the alternate prayer always.
Dr. Siddique, that's inferential. Until and unless he dies, there cannot be a question of ashes.
The fact that every head of state from India, prime ministers have paid obeisance there at Renkoji temple is recorded. So let me answer my lord's query. My lord has raised a query, let me answer. Go sequence wise. Come to 37. First, my lord's query about family members.
First, we would like to know that how many family members, surviving members are there.
Yes.
One of the greatest leader of this nation, no doubt about it. So none of us bow before
let me
him and
answer one by one.
His supreme sacrifice.
Exactly.
But we would like to know that how many family members are surviving.
Netaji has 1 child only. Sole first class heir is Miss Anita Paff, lives in Austria. I made sure that she's on the screen now. Answer number 1. She's sole. Number 2, please come to 37. Let me place
before us.
She's
not the petitioner.
Well, the petitioner is the grandnephew who lived with them.
Let's see the heir come before us.
No, Malas. Therefore,
no, Dr. Singh.
The heir supports.
Heir supports. It cannot be a fight behind the clouds.
No,
therefore, if the heir wants the ashes or what the remains of this great hero
in fairness,
to be brought to our country,
yes,
the heir must come before.
I hear, my lords. I expected their question in fairness. So give me 2 minutes now. Your lordship has raised many questions. Come to 37. If I can answer, I'll make sure that she files something. Just turn to 37. Come to 37. This is the daughter who's on the screen now at page 37. Just turn to page 37, Manas. She's writing
Dr. Singh,
in 25 and 26 now. Official statements.
We made it very clear to you, we respect her sentiments
because
there are differences to our knowledge in the family itself.
Will my lords allow
with regard to the incidents which occurred?
So will my lords allow for 1 minute the lady to speak and I'll file the additional affidavit from her?
No. We are great hurry also in this petition. We know the timing also. Don't compel us to say so many things.
Well, there is no timing in this because she's been writing consistently.
Everybody
else has got mixed up in it. She has never said no.
matter as a
Then let me allow me to withdraw and come back, with the appropriate. Just allow me to withdraw. With the liberty. With the liberty. Your Lordship is allowed me to withdraw with liberty. I'll make sure that she files an affidavit. Otherwise, my Lord, the Chief Justice allowed me to withdraw with liberty.
All right. Then Supreme Court seeks and permitted to withdraw this petition.
Right.
May it please your lordships. The fundamental contradiction that I would like to bring to the notice of the bench here with my writ petition 285 of 2026 is RBI and government claims India booming economy, controlled inflation, raising per capita income, yet citizens cannot cope and necessitating interim PF withdrawals, treating retirement corpus like an ATM, and silver mortgages from April 1st it's going live. which is the last resort of the poor is allowed to be pledged. So I would like to bring it to the notice that if economy is truly rising, why distress-driven asset liquidation policies? So that's my primary concern, Your Lordship. What I notice is, a couple of points where, RBI itself shows the evidence of exposes the fragility basically in economy here. Cash reserve ratio. Sorry.
Where are you living?
I am put up here in Delhi right now. Put up here in Delhi as of now, but born and brought up in from Andhra Pradesh.
You are giving your complete address also of Andhra Pradesh.
Yeah.
What are you doing?
I used to serve software industry earlier, but right now I'm.
You are not doing anything.
Yeah.
So now you have started filing PIL. How many PILs you have filed?
This is my second PIL. This is my second PIL. Yeah.
What happened to your first PIL?
I'll speak about that also in a bit, Your Grace. Primarily, points that I would like to mention here is.
Come later on. First, let us. What happened to your first PIL?
Okay, that got dismissed. That got dismissed. I mean, I'm coming there. I mean, it comes as in the flow, Your Grace. So I would beg your pardon for that.
What is your qualification?
MTech in information security, and I served as software delivery manager.
So the person who is having MTech qualification, yes, your annual income is how much you are disclosing?
Right now, I'm jobless and I do not have any income.
So you are saying approximately rupees 1 lakh per annum.
I trade,
1 lakh rupees in a year.
Your Grace,
from where are you getting your?
That's what I'm saying. I'm trading, Your Grace.
So how many family members you have?
I do not have anyone.
You have family.
Yeah.
All right.
I'm all alone. I do not have anyone. I'm no dependents or anything. I'm all alone, and I trade, the stock market basically for my living, and I just make whatever is required. I'll just make it through my trading things. Right. The term cash reserve ratio, CRR, cash reserve ratio says it's supposed to be address the part of reserve. That's basically the reserve. However, in last year, June, if we notice, cash reserve ratio was reduced to 3%. If we look at the history, ever since the RBI was established, the only time in the history you would notice CRR went down to 3% was during pandemic. 2019 pandemic, when the country was completely shut down, nobody was earning, no income was generated. At that point of time, using reserves makes complete sense. But when the economy is rising, economy is booming, you're claiming, you're making such claims, and in contrast, you're reducing CRR to 3%. In my previous petition, which got dismissed, this was my primary concern. I'll speak about why that got dismissed. I'll speak everything in the right now, Your Grace. So my primary concern was about cash reserve ratio reducing to 3%, while banks gamble, or they do business with 97% of their customer deposits. Right. For example, considering something like S-Bank scam. If say February 22nd, 23rd, it came to notice. I mean, it's in the news, basically, IDFC Haryana Chandigarh branch scam, where about 590 crores. That was very small amount. Considering IDFC Bank IDFC Bank, who has got the customer deposits of 2.8 lakh crores, considering 3% CRR would be of.
Problem with this? Tell us first. Listen the question. What is your problem with these schemes or?
No, I'm just raising the contradictions before I go to my case.
Why should we unnecessarily waste our time, judicial time, on an economic issue? Go and represent. Why have you not approached any authority?
Your Grace, I just want to. Okay, fine. I'll go directly.
First petition, I think we didn't impose the cost only because knowing that you might necessarily.
Okay. Wait, right.
Any problem with any, how do we understand? We are not the economists. We are not the subject experts. Go and tell the authorities if you have any problem.
I agree, your Grace. I mean, in fact, this was the reason last time it got dismissed. Fine. Fine. I raised RTIs with EPFO and Ministry of Employment and Labor for.
We see no reason to entertain the same. Accordingly dismissed.
Your Grace, I pardon you, Your Grace. Let me. I beg your pardon.
3 of 2025, which was dismissed by this court on 7th October 2025, after observing that the matter pertains to the economic policy which fall within the domain of the executive. The petition was permitted to represent to the Union of India, if so advised. However, instead of submitting any such representation, at least nothing on record, he has filed the second petition, which is nothing but abuse of process of law.
Your Grace, I would like to mention one statement here, please.
Being not maintainable, with a word of caution that in case the petition found indulged in filing this kind of frivolous petitions in future, exemplary course shall be imposed.
Lordship, the challenge in this petition is to the constitution of the adjudicating authority created under the PMLA. Your Lordship, challenge here is to the constitution of the adjudicating authority created under the PMLA. The authority does not have a judicial member since 1st of September 2020. Your Lordship, similar petitions are pending.
You can tell the authority that your appeal should be decided only after some judicial member is appointed. That we are dealing with on administrative side, not in another PIL.
Your Lordship, there are similar petitions.
The non-member or judicial member is a good ruse for. I have nothing to do with my husband. Is as if you are living separately from the husband. When you buy property from his asset, then your husband is good.
The property is
When
purchased.
question of liability comes, then no. I'm an independent owner.
Your Lordship, the property purchased was in 2004. Your Lordship, the allegation pertains to the period of 2015 to 18. Your Lordship.
That on merits you can contest. We are not saying.
Your Lordship, there are similar petitions pending before this court.
Let
Your Lordship.
it remain pending. We will take care of those petitions also. Become paradise for dishonest people. So the issue with respect to appointment of judicial members as presiding officers of the adjudicating authority under PMLA shall be taken up separately in the PIL pending PIL reforms in tribunal. So far as the petition is concerned, Commerce will be at liberty to pursue the matter before the authority concerned without prejudice to our rights, without prejudice to our plea that such pending proceedings should be decided by a judicial member. In the event of an adverse order, the petitioner shall be at liberty to agitate such plea before an appropriate court. With these observations, we see no reason to entertain the special petition, which is accordingly dismissed. Next, for the OPC directive to list SLP civil number 12865 of 2018 for hearing after informing the counsel for the parties on 13th April 2025. Monday.
Your Lordship, in a similar petition in the high-tech matter, your Lordship has issued notice, Your Lordship. In a similar matter, Your Lordship.
We have listed that matter also. You are saying not similar, you are only saying that the judgment which has been relied upon by the High Court, against that some SLP is pending.
Yes.
Ignore that judgment. Independently, the reason given by the High Court is correct.
Your Lordship, in the meanwhile, the adjudicating authority may not.
Not come. Union of India. Other findings. To believe
Your Lordship, in similar matters on the same issue, coordinate benches have issued.
We list that also. We are listing that matter also, which you have pointed out. If there is another one, we will list that also.
Your Lordship, in the interim, I may be because the coordinate benches have granted protection, Your Lordship.
Tell us the number, we will list, and we are not inclined to grant any interim today.
Your Lordship, the other matters which are similar matters are SLP Civil 5066 of 26.
You please give us the number, we will list all these matters.
We will, Your Lordship. Lordship, in the meanwhile, the adjudicating authority
listed along with case number so and so.
Your Lordship, in these matters, the protection granted is that the adjudicating authority may not proceed, but I will give an undertaking to the court that I will not alienate the property. I can give a similar undertaking.
That is only an interim arrangement, which we have said your plea survived. You go seek adjudication. Tomorrow adjudication is supposed in your favor. Are you going to challenge it on the ground that it by administrative member? You are not. Therefore, we have said this plea will not be taken to have been surrendered by you. Go and see. If the adjudication in your favor, what will happen? You will not say this order is without jurisdiction.
Lordship, my apologies, but by the orders that we've seen so far, Lordship.
We have kept your issue alive as far as your ground is concerned.
Yes, Your Lordship. Your Lordship, the jurisdictional issue will not be decided by the authority itself, Your Lordship. That's the only concern. The authority today cannot decide if it has the jurisdiction to hear it or not. That's the concern that we have. That's why we've...
The issue of jurisdiction has been decided by the High Court. In the earlier judgment also, it is not the person, aggrieved person is before us. It is the Union of India on account of some observation that they are...
Yes, Your Lordship. That is the J. Sekar matter, Your Lordship. But in the other matters that I've just forwarded the orders, the accused...
It is not a quasi-judicial kind of where some independent rights are to be established. It's only a finding of fact.
Your Lordship, there are issues whether these are proceeds of crime or not. Those require judicial determination, Your Lordship.
That's why we listed that matter will collect.
Lordship, in the meanwhile, I may be attacked and I may also be given the same protection that those parties have been given. Those are all affected parties that are here, Your Lordship. Those two orders that I have forwarded, Your Lordship.
Which orders are you pointing out?
Lordship, I'll just... Your Lordship, there is...
What is the date in the first matter?
Your Lordship, there is one order which is passed by Your Lordship, which is 16.
This is not the point where we remember this case. This is not the issue we are with.
Your Lordship, but Your Lordship may see Samrit Surekha, which is SLP Civil 5308 and SLP Civil 5066.
So
in
your case, the member is from the Indian Legal Service.
No, Your Lordship, he is not a legal services member, Your Lordship. He's a finance. He's a member from the financial services, Your Lordship.
He's not from the legal service.
No, Your Lordship. In fact, Your Lordship, it is an admitted position that since 1st of September 2020, there is no judicial member, no legal member in the adjudicating authority. Your Lordship, if Your Lordship sees SLP Civil 5308 and 5066.
This is not the issue involved in these matters.
Your Lordship, I'm carrying the High Court orders. This issue has been raised in these petitions, Your Lordship.
We remember because this matter was before our bench only. We remember the judgment also.
Yes, Your Lordship, that is the high-tech matter, Your Lordship. But the other two matters, Your Lordship, Samrit Surekha...
Other two matters, if someone has misquoted about high-tech matter, we can't really comment on that.
But in these matters, Your Lordship, the issue has been raised. I'm carrying the High Court judgment also to show to Your Lordship.
1169 is the matter which is before our bench.
Yes,
and that has been referred to, got tagged with those matters.
Yes.
What is the date in this matter, by the way?
Your Lordship, these are in May, Your Lordship. The date given, Your Lordship, is in May.
Your argument before the High Court was whether the quorum should be of 2 members.
Whether it should be of 2 members and also a judicial member, Your Lordship.
That argument is not there.
Your Lordship, it is a part of the petition. It is not recorded in the order, Your Lordship. Your Lordship, we may be tagged to the same batch. We may also be allowed to address the court on the issue.
That this issue has not been agitated before the High Court. We don't know what is the pleading, but at least in the oral submissions recorded, the fact that the separation of power doctrine is being infracted because of absence of a judicial member was never argued. The question was one of quorum as to whether it should be a two-member bench or a single-member bench can discharge the duties under section 6(2) and 6 because of subsection 5 of section 6.
Lordship, this is a ground raised in the petition, Your Lordship. I can show from the
That
petition.
is, there are 100 grounds are raised.
Your Lordship,
Whether
the
it
matter,
was
Your Lordship, the matter was argued. While the judgment is detailed, the matter was argued for 5 minutes, Your Lordship, because based on the J. Sekhar judgment, it was the detailed order was passed later.
Only J. Sekhar does not go into this question.
Your Lordship,
J. Sekhar again dwells on quorum, whether it is a single member tribunal or multi-body tribunal. There, J. Sekhar holds that because of subsection 5 and subsection 7, it cannot be inferred that the tribunal must consist of more than one member. But what you are trying to tag is a different thing, that a tribunal must have a judicial member.
Your Lordship, both issues have been raised, Your Lordship, and in the J. Sekhar entire batch, there are several petitions from different states wherein both issues have been raised, Your Lordship. Your Lordship, the contention here is that if at all it's a single member tribunal, it should be a judicial member. So, Lordship, therefore, my only request is that we may also be tagged to the batch. We may also be permitted to address the court on the issue.
The only issue ground taken by you is J. Sekhar judgment. J. Sekhar judgment, as far as agreed parties are concerned, private parties are concerned, they have not challenged. Union of India is before us.
It's the Union of India which has challenged, Your Lordship.
Therefore, how can you take advantage of that?
Your Lordship, I can show the relevant grounds, Your Lordship, where we have raised this issue before the Supreme Court also, Your Lordship. I'll just show the grounds from the petition, Your Lordship.
Union of India, that part of the judgment where this adjudicatory authority's composition has been upheld by division bench of the High Court. That part is not under challenge on behalf of the agreed person.
Yes, Your Lordship, but Your Lordship, with the J. Sekhar batch, there are several petitions which have come from different high courts. This issue has been raised, Your Lordship. It's a connected batch of several petitions.
There is no other petition except these two petitions which you are referring to. There somebody has cited pendency of SLP before our bench. In some other matter, where this issue is not there.
Your Lordship, that reference may not be correct because we checked the order that passed by Your Lordship and the High Court order. It has nothing to do with the quorum issue, Your Lordship. We've checked that.
This is what exactly we are saying.
Yes, Your Lordship. We have checked that, Your Lordship.
You are very fairly telling us, but that's why we are pointing out that how these matters then raise this issue. I'm sorry to point out, someone said that the first bench has granted this order. And please take it.
Your Lordship, we checked the High Court judgment. It didn't deal with the quorum issue. But Your Lordship, my only request is that with the J. Sekhar batch, the other matters have been tagged.
How we find that your matter is the same issue? The only issue, similar issue is only in J. Sekhar's case. J. Sekhar case, private parties are not in
Your Lordship, in the batch, there are private parties which are before Your Lordship. In the J. Sekhar matter, there is a batch of matters where private parties are before Your Lordship, Your Lord. So therefore, we were requesting that we may also be permitted to be...
At least now, are we clear that you don't rely upon this Simrit Surekha or Tushar Bansal's order?
I am relying on the Samrit Surekha matter because it's the same issue, not on the high-tech judgment. I will not rely on the high-tech order passed by Your Lordship because it does not...
Surekha has been tagged with that high-tech.
That, Your Lordship, my apologies, Your Lordship, but I will not be in a position to answer that question, Your Lordship. My apologies for that, but can't answer that question, Your Lordship.
Sure.
Whatever was argued was only on quorum. We actually searched because if the
In our matter, Your Lordship, we were heard for 3 minutes, Your Lordship, based on the J. Sekhar judgment. We were told that you have no locus to be here in view of the J. Sekhar judgment. The detailed order was passed later, Your Lordship. That's the only problem. Your Lordship, Your Lordship, the only request here, Your Lordship, the entire batch is pending here. Your Lordship may not give.
That you please tell me, we are showing that this, in this matter, there is a misleading statement.
Yes, Your Lordship. We will. I will not say misleading because that's for Your Lordship to say. But
You can say.
But Your Lordship, I will not rely on the high-tech order. I cannot
say
rely on the
about
high-tech
your colleague, but this is, isn't it a misleading?
Your Lordship,
That matter has nothing to do with it.
I am not relying on the High Court order. Lordship. I'm relying only on the fact that the entire batch is pending before Your Lordship. So I may be tagged to the batch and be permitted to address Your Lordships on the issue when it is taken up. Your Lordship, if Your Lordship may see page 466 of the SLP, this is a part of my petition filed before the High Court, Your Lordship, which is ground J, Your Lordship. Your Lordship, there is a subheading J. It says composition of adjudicating authority suffering from the vice of quorum non judice. Your Lordship, for that the entire impugned proceedings and further Your Lordship may kindly see the paragraph A, Your Lordship. It says, for that the entire impugned proceedings are further rendered illegal and unconstitutional, being hit by the vice of quorum non judice, apparently a member as acting chairman who may not be from the field of law alone is conducting the proceedings within the nomenclature of adjudicating authority.
Entire argument essentially was not that he's not a member of the legal fraternity. It was whether it is to be by a two-member bench. And even if you say J. Shekhar primarily is going on that proposal.
Your Lordship, what has been recorded in the impugned order here, Your Lordship, is entirely based on J. Shekhar and not the petition here. If Your Lordship sees this...
What is the point in Tushar Bansal?
Your Lordship, there is an issue of quorum non judice raised in that. I will just forward the High Court judgment, Your Lordship. We forwarded it.
No, but then how it has been got tagged with high-tech?
Your Lordship, my apologies. I'm not in the position to answer that question, Your Lordship, but they are not. The only commonality in the orders, Your Lordship, is section 5(1).
Now tell me at the earliest which Monday is available.
Which one?